title differently. Thank you.
The Honourable David Parker.
Can I just respond to Materia Ture's comments about saying that I lacked an understanding as to why it was discriminatory in respect of existing freehold. Is that those areas that are in freehold title would not qualify as areas where there are unextinguished customary rights, and therefore the issue doesn't arise. So the second point that Materia Ture made, I agree with, and that is that if there are in the foreshore and seabed and they are subsequently overridden in favour of some public project or some private project like mining, then there ought to be fair compensation for the loss of the right that has been found to exist. And that was one of the issues that we raised at Select Committee, which the Select Committee, because it ran such a poor process, didn't even report to the House on. It was an issue that was of to others, including ACT, when they saw that effectively we could be saying that there is an existing customary interest in the foreshore and seabed of this legislation, and is that the grace in favour of a future government rather than a right at law as exists under the Public Works Act, where there is a public work that takes away some right. So that's an example of where I do agree with the Greens that that's bad law, and we have an amendment on the floor of the House to actually remove those provisions so that it's not of that effect. Can I raise another issue which relates to these Part 1 definitions? Now, Part 1 sets out the outline of the Act, and it says that amongst other things that we're going to codify what is or isn't an extant customary interest which should be recognised in a customary marine title. And one of the problems that we get ourselves into here is that we've taken it upon ourselves in Parliament to try and codify things that the courts have never had the chance to properly interpret and say what is the common law position, what is the right or the range of rights that may be existing, what are the range of rights that may have used to exist. For example, perhaps the right to mine for oil and gas, but which were clearly abrogated by the nationalisation of that resource back, I think, the Attorney General might be able to correct me as to the date. What was it? 1937. But was nationalised in the Petroleum Act in 1937 and customary interest that would be able to be part of a customary title. The government's attempt to codify these provisions in Part 1 fails for a number of reasons. One, the government and the Maori Party said that they were setting out to settle this, and yet we have the Maori Party, through their leader, Honourable Tariana Turia, through their deputy, Sharples, and through their whip, Te Urua Flavel, all saying it's just not accepted by them as settling the issue, it's just a first step along the way to achieving a wider ambition. So that shows that the primary ambition of the government to settle this through this codification of what are the appropriate threshold tests for establishment of a customary title just doesn't pass, and that's putting aside, and I don't mean to put aside as irrelevant. I actually think Hone Harawera's concerns about these are also relevant in the underlying dispute. What are some of the problems as far as ACT are concerned? Well, ACT quite rightly make the point, why is it necessary of fishing or a right of navigation doesn't why it doesn't mean that you can't get a customary title? That's an argument that someone might determined either in a New Zealand court or any overseas jurisdiction. They're right that is an argument that might be relevant, that ought to be listened to by the court. Conversely, the arguments that some Maori submitters made that these requirements of proving exclusive use and control are too high a threshold test, that might be right too. that they don't have the opportunity to actually claim that in court because they're stripped of, I argue, Mr. Chairman, they're being stripped of rights to go to court, and because the codification of those issues puts that beyond the codified tests rather than determine what the proper customary marine title. Mr. Chairman, that I think is at the nub of where the Labour Party got to on this. We freely acknowledge that the existing the existing Foreshore and Seabed Act is wrong in that it doesn't allow people to, but we also went further and said, look, Parliament's now had 2 cracks at codifying this, and we haven't done it in a way which settles the issue because there is no compromise available which the parties can accept from the different sides of the debate. Therefore, the whole thing should be referred back to the courts, preserving public rights of fishing and access and inalienability of customary interests. That's really all the legislation needs to do, and so that's why we've put up provisions that amend the various provisions in this part of the Act to that effect. Can I also say, in respect of the change to the threshold test, that with the absence of legal advice as to the effect of the change of the test, I remain ignorant as to what is the true effect. And I'll give you an example of where this was being spun by the government to different submitters or different interest groups to different effect. Te Aroha Flavel was quite rightly concerned that land confiscations that were improper period post-colonisation should that a claimant is disentitled from claiming a customary interest in adjacent foreshore and seabed. And his point of view was that he thought that if you went to court and argued that you might be able to convince the customary interests are extinct. Now, the definition in the original Act, and that the requirement to ownership of has been removed. That's no longer a prerequisite to establish. But that was interpreted by National Party members who were trying to placate the Maori Party. You had your land confiscated, didn't disentitle you from establishing a title. But what they didn't say, what's the effect of the provision that you've got to prove, and I think the words are, and the Minister can correct me if I'm wrong, but continuous and exclusive occupation. Control the adjacent land and therefore down to the foreshore and seabed. How can you show that you had control of the adjacent area of foreshore and seabed? So none of these issues have been explored at Select Committee because we didn't have advice, because the You asked the question, but then you blocked us getting any legal advice so as to get the answer. That's not exploring it. That was very, very poor process. And so the poor old Maori Party are left ignorant that although it's true that that the fact that adjacent land was confiscated isn't an absolute bar to proving a foreshore and seabed interest in the adjacent foreshore and seabed. It may well be a de facto bar, given that you won't be able to show exclusive control of the adjacent area of foreshore. And I know that because the Attorney-General has as much as confirmed that to me in discussions that I've had with him. But I haven't been able to explore that in a way that gives me the benefit of either the Crown legal advice or legal advice to the Select Committee, because we were blocked from doing so. So you can see why, at the end of this, there will be a sense of grievance on the part of Maoridom, who will feel that they've been done over here. I actually don't necessarily agree that their view of the common law test as being a lot more than that is right, but I can see why they will feel that they have had the effect of this legislation misrepresented to them, and therefore they will have an ongoing sense of grievance, and this will not be settled. And that, of course, is why this legislation fails the test that the Prime Minister laid out for it right at the start when he said, well, we're not going to proceed with this if it doesn't settle it. We're not going to proceed with this if it hasn't got broad support. And that is but one instance as to why that is not the case. Mr Chairman, the consideration in the departmental report of this Part 1 of the bill is 50 pages long. It goes from about page 72 to page